We are joined by Carl Marlinga, the former Macomb County Prosecutor. Thank you very much for being here. Still with us is Lillian Diallo, defense attorney. So, Mr. Marlinga, can you tell us, first of all, what your just initial reactions are to this hearing?
Well, I think that both the prosecution and the defense are doing the optimal job for their respective sides. I think that Karen McDonald has been brilliant in the way that she has separated, well, she has presented the horrors of the crime, but then even made the point, which I think is important if there's any appeal of this, that Ethan not only had the chance to consider the consequences, but he actually planned for his survival, meaning that he wasn't going in there with a reckless disregard for everything. He was still trying to put down the gun, be captured alive, and as Karen said, so that he could all the more enjoy the misery that he had created. If there is a case, again, as the prosecutor said, which says that normally you do not want to put children in prison for life without parole, but since the Supreme Court said there could be such a case, I think her question, her rhetorical question is a good one. If not this case, what case would then qualify? On the other hand, on the defense side, I think that the presentation has been brilliant in its own way, knowing that the horror is going to be there no matter what the mental state of the defendant is. And so you can't just look at the horrific consequences and all of the suffering, all of the pain. The question is now, is there something about that defendant that doesn't excuse the crime, but says that at this young age, life without the possibility of parole is over the top, it's too much, and in the words of the Supreme Court, is the child incorrigible? That means impossible to be corrected. And I think the psychologist's testimony today, although long, got to the point where the feral child is the perfect words to use, that yes, apparently grown up, taken care of, but emotionally left abandoned.
And Lillian, you've talked about the fact that you think that this has really done the point of a Miller hearing. We've carried that out. Why do you feel that way?
Because it moved me from that just stuck position, right, of the horrendousness of the crime, right, the atrocities that were committed on that particular day by that particular person, that shooter, right? So now we get to see other things, right? We get to see the mind, the horribleness, right, that he had to grow up with. And that doesn't give you the right, though, to me, to take lives like that, right? It's just, what is the punishment here, right? And like I said, up until one of the prosecutors, I think it was prosecutor, the last one, was going on, and he went after, personally, it looked like, the last witness. This has been a great job on both sides, right? But I think sometimes we might get a little involved in whatever we're involved in our position. And that's when we need somebody to say, hey, and I've had that happen all the time. Okay, now go this way now. Okay, I need you to, stop, take a breath. You've been a judge for many years, right? You were a former prosecutor, so sometimes we're just humans. We have to take a breath in those courtrooms and just step back, because we get so into it, we're just so in. And we're on and not off at all.
That's a really good point.
Yeah, I think as a defense attorney, I would stress that, look, as bad as this is, horrific, bad, horrific, there's no words that can qualify to describe what happened. If the person was provably insane, that is unable to tell right from wrong at the time of crime, no matter how bad the crime, you would still have to legally say not guilty by reason of insanity. And so you can't measure what you should do by the consequences of what happened. On the other hand, from the prosecution side, I think you can say that look at, again, this is more than just pre-planning. This is not the usual crime. This is a crime in which the perpetrator intended to survive, meaning that he was going to relish the horror that he created. And one other thing that I think I would slip in and remind the judge, that the Miller versus Alabama decision was a 5-4 decision. The liberal bench controlled at that time. Now it's a 6-3 conservative bench. The dissenters are now joined by 3 more conservatives. If you do say life without parole, the chances that you will be affirmed if it goes all the way up to the Supreme Court are excellent, because now the bench reflects what the dissent was in those days in 2012.
All right. Thank you both so much for your insight and expertise. We appreciate it.